So hello, welcome. This is a workshop on estate planning, and for first-time home buyers or anyone really. But I mean, from a real estate perspective, I think that's a specific niche of folks that I think could benefit from some of this information that Deb's going to share. I think I know that the thought of estate planning is like, oh, that's like what wealthy people do. Like you think of trust fund babies, and that's kind of the vibe you get when you think of estate planning. And so when I first heard Deb speak about, what is an estate plan, and it's not just a will or a trust, and what are kind of like the financial consequences of not having one, I was like, well, darn, this is actually pretty bad from a wealth building perspective if you aren't prepared, and can kind of negatively impact folks who don't have this kind of knowledge. So the goal is to kind of democratize this. And I'm Sammy Lyon. I'm a realtor. I was in education for over a decade before getting into real estate. And so my folks are like the nonprofit education teachers. Like this was, we weren't the folks trying to get like the investment banking jobs and I didn't know what you could do in the for-profit world. Like it was just all nonprofit. So I think that's like my personal goal, is to kind of create more of this knowledge for folks who may not have had access to that. And so Deb and I are in the same networking group, and she presented to us. And I pride myself in kind of knowing a lot of important things, but I was like, oh, I'm very unprepared after listening to Deb talk. And I was like, more people need to know this. And she's just so like open and warm and really willing to share information. And it's really great at kind of simplifying it and making it more accessible. So I'm super grateful that she wanted to do this workshop together. And Deb Young, she has her own law firm. So I'll let her kind of share a little bit about herself. But we'll do a presentation and then Q&A. So if you have any questions at all, just throw them in the chat. I'll gather them up and we'll make sure that they all get answered. So yeah, Deb, take it away. You can share screen and share your slides, and thank you so much.
Okay. Hi, everyone. My name is Debora Young. I go by Deb Young. Nice to meet you, and thanks for joining us this Thursday night. And I'm an estate planning attorney and a probate attorney and a conservatorship attorney. And all of these different areas go hand in hand. And I will give you a little summary and a little education of what is estate planning, what is probate, what is a conservatorship, why you want to avoid it, why you want to prepare for it, and what to do if you have not prepared. And as Sammy touched base, estate planning applies to everyone. People who have young children, people who own real property. At least 1 out of 2 adults will be incapacitated at some point. So you need to have an advanced healthcare directive, a power of attorney. So there are all these documents that actually affect the majority of people, or there's a chance of it affecting us, but without actually having these in place, you may be subject to a lot of expenses and hardship. So I'm just going to touch base and give an explanation about all of these. First, when we talk about estate planning, actually, let me share my slides. Okay, so when we talk about estate planning in general, it's 5 separate documents. Let me go to the next slide. Okay, so when we talk about estate planning, there's different tools that come together to make an estate planning. Like when you go to an attorney and you go to prepare your estate plan, you don't just get a will, you don't just get a trust, you actually get 5 separate documents and sometimes additional documents that together comprise your estate plan. Each of these documents serves a completely different purpose for a different circumstance. So I'm just going to touch base on all of them and tell you how they benefit you and why you need it. So number 1, the living trust. It's a revocable living trust. What that means is that you can change it at any time during your lifetime. It doesn't change anything with taxes. It helps you for taxes in the future after you die. But in the time being, creating a revocable trust has no negative consequence. Why do you have a trust? The number one reason people want to have a trust in California is to avoid probate. And probate is the courts, it's a court system that allows for assets to be distributed to family members when someone passes away. And I'll touch base on it, but in general, the reason you want to avoid probate is that it's very expensive. And I'll have a slide later that will show how expensive it is. It's triple, quadruple times the price of an estate plan. And also it's very time consuming. It takes over a year to go through the probate process in California. Now, because of COVID, we're looking at about a year and a half. And just the costs of probate alone, with just paying the court fees, it's about $2,000. So if you can imagine what the fees with the cost are going to be. And it's public record. Once somebody files a petition for probate, they can just go online, search your name, pay $1, and find out what's happening in your family. So the reason you want to have a trust, one of the main reasons, is that you can avoid probate. You don't want to have the expense, the time it takes to distribute the assets, and also the publicity. Another reason you want to have a living trust is because a living trust allows you to control how money is distributed to kids. So if you don't have a trust and you have kids, once they hit 18, they get all of your money. They can get millions, they can get hundreds of thousands, and kids will blow through that, especially right now with bad influences because of social media and friends. You can't trust an 18-year-old with $10,000, yet alone $250,000. So by having a trust, you're able to control how your kids get money, and you can give it to them in increments. So if they have big life events, getting married, if they're opening a business, graduating from college, they're able to get big chunks of money. But then whomever you've named as a trustee to manage your trust for you will be able to step in your shoes and pay for your kids' everyday expenses as you would. It's kind of also allows to keep the normalcy of the expenses of the children. So 2 reasons we have a trust: avoid probate and control how money is distributed to kids. Another part of how money is distributed to kids is maybe your daughter or son is married to someone you don't like, and you would hate for them to receive their inheritance and then mix it up with the money with their spouse, and it's done. It's commingled, it becomes community property, and the son-in-law you hate is going to get your money. So another way of controlling how it works is that if your money is kept in trust, whatever you're giving your daughter is kept in trust for her, it kind of retains a separate property character. So in the event they end up getting a divorce, the son-in-law you don't like is not going to get that money. So that's another benefit of another control of being able to control how money is given to kids. Another benefit is, let's say one of your kids gets involved in a lawsuit. If their inheritance stays in your trust and all of it is not distributed to them, then it's not considered to be theirs technically because it's connected to you. Then creditors cannot come after it. That's another benefit of having a living trust and how money is controlled for the kids. So living trust we talked about. Next document is called the will. A lot of us know what a will is. A will is the document that you get to write down who's going to get what when you pass away. Another term for a will is called a pour-over will. And the reason it's called a pour-over will, because every time you create a trust, at the same time you create a will. If you forget to put assets in the name of your trust, the will is going to pour it into your trust for you. So let's say you have a bank account with $250,000 in it, and it's not in the name of your trust. But you want the advantages of what we talked about, having a trust, how the money is controlled and the money is distributed to your kids. Your pour-over will, albeit through the court system, will allow the money to be poured into the trust and then distributed to the kids according to the terms of your trust. Another main purpose a will serves is that it allows for people with minor children to name guardians for their kids. And the reason a will is the only document that allows you to name guardians for minor children is because when you pass away, your will has to be probated if you have minor children. And this is a document that the courts will look at. Another document I tend to prepare is a nomination of guardian. And again, this is a document that they can be showed to the court to show who you want to take care of your kids when you pass away. This is especially important if, God forbid, mom and dad are involved in a car accident together. And what happens is husband side of the family and wife side of the family end up fighting over the kids. So, and sometimes there are people, or maybe husband hates his brother and he would never want brother to be guardian over his kids. I've even prepared wills where explicitly we've said that husband's mom had alcohol problems. So we explicitly said that she can never be their guardian. She can never be left alone with them. You can include whatever safeguards you want to protect your kids' interests. So that's why we have a will. Then the next document we have is called the durable power of attorney. A lot of people know what a power of attorney is. You give someone power of attorney to make decisions for you. Sometimes there's a specific power of attorney. You're going out of town, you give somebody power of attorney to finish signing real estate documents for you. But what a durable power of attorney, and in the context of an estate plan, is a durable power of attorney comes into play during incapacity. God forbid you get in a car accident, you have a stroke, you get diagnosed with dementia. You just never know. So this document will allow someone to make financial decisions for you. What if you're in the middle of a real estate transaction? What if you have $30,000 sitting in a checking account at the bank that pays you all of your bills? Someone will need to access that money to be able to pay your bills. So this durable power of attorney will allow whomever you've named to kind of step in your shoes and deal with your finances if you're incapacitated. Now, a power of attorney dies when the person dies. It does not extend after death. It only comes into play when somebody is incapacitated. Another document that's very important during incapacity is called an advanced healthcare directive. An advanced healthcare directive comes into play at the same time as a durable power of attorney does. When someone isn't able to make medical or financial decisions for themselves as a result of incapacity, that's if they have car accident, stroke, heart attack, dementia, you can name it. And what an advanced healthcare directive does makes it easier for the family members to make decisions, for end-of-life decisions, to make decisions regarding doctors. And without an advanced healthcare directive and without a durable power of attorney, then you may be subject to a conservatorship. A conservatorship, it's a court process where an adult is appointed over someone who's also an adult but does not have capacity to make medical or financial decisions for them. So the same way a parent is guardian over minor children, a conservator is conservator over an adult who doesn't have capacity, whether they're bedridden in a hospital in a vegetative state, or they've had a stroke, or they have dementia, or they have Alzheimer's. It comes into play, but basically conservatorship in a capacity of incapacity. And the capacity of incapacity comes into play when someone is not able to make medical or financial decisions for themselves. And if they don't have these two documents, then different financial institutions or different medical institutions want to have proof of who's going to be making decisions for you. And if you don't have these documents, then your family or friends will have to go to the court and be appointed conservator over your person to make medical decisions, over your estate to make financial decisions. Conservatorships are very expensive. Just the court filing fees are $1,200. In addition to the person filing having to pay for the attorney, which ranges between $4,000 to $6,700. Some attorneys charge $10,000 for a conservatorship. The court's going to appoint a neutral attorney to represent the incapacitated person. Guess who's paying for that extra attorney? The conservatee's estate. So a lot of money gets wasted in a conservatorship. But just one side note, if the proposed conservatee, the one who does not have capacity, does not have enough money, the County of Los Angeles will pay for that attorney. For not the attorney who's filing for the conservatorship, but the attorney who's coming into the case to represent the proposed conservatee. So we talked about the 4 documents, and the last document, the easiest document to talk about, is the HIPAA authorization. These days when we go to doctors, they give us that little, what is it, the signing pad, and they say sign this for a release of HIPAA. And HIPAA authorization is just for release of medical records. And the way it works in the context of an estate plan is the person that's going to be making medical decisions for you, you want this person to also have access to your medical records. What if you're being transferred from UCLA to USC? You need your medical records transferred between the two different hospitals. Then the person named in your HIPAA authorization has the authority to request to get these records and have them transferred. So these are the 5 documents and what estate planning is. So again, I talked about, we do estate planning, which is the 5 documents. Then we have probate and then conservatorship. So I'm going to go down the slides. So these slides just basically show us that these documents, estate planning, comes into play when somebody has physical incapacity, physical disability, or even mental illness. And I'm going to skip through these and talk about probate. I'll show you why it's so expensive. So as I said, probate, let me go back here. The disadvantage of the probate, as I said, it's very costly, very time consuming, and there's no privacy because it's all public record. It takes about a year to a year and a half. It used to be 10 months when I created these slides, but unfortunately it's taking much longer because of COVID these days. And the cost is very expensive. And let me show you why. So first, when we're looking at where these numbers come from for calculating for a $500,000 estate or $1 million estate, this is gross. So if somebody owns a condo that's worth $500,000 and they owe $450,000 on it, the fees are still calculated on the $500,000. Nobody cares about the mortgage. And same thing goes for the million. So whenever you have a $500,000 estate, the personal representative, the one who's going to be in charge, is going to get $13,000. The attorney is going to get $13,000. If the case ends up being the type of case that requires extra work, if you have to sell a real property, the attorney has to deal with the real estate agents. Sometimes you have to go to court and auction the property. All of these are, the attorney is entitled to extraordinary fees at an hourly rate. Usually the hourly rate is between $300 and $400. And as you can imagine, it adds up. And then we have filing fees, publication fees, appraisal fees. So just the costs for a $500,000 estate, you're looking at about $28,000. And then if you're looking at $1 million estate, you're looking at costs of almost $50,000. So that's exactly why you want to avoid probate. You can pay a few $1,000s and have a trust and save your money, hard-earned money, for your family members rather than them paying for the cost of probate, not to mention how long it takes, and not to mention that it becomes public record. So this is what probate is. So, and I already discussed the revocable trust, that you could revoke it. I'm gonna go to what a conservatorship is. I'm not sure if anybody has read in the news, but yesterday, Britney Spears, who has an ongoing conservatorship case in the Los Angeles County Superior Court, she has been under conservatorship because they went and deemed her not to have capacity to make medical or financial decisions for herself. So what happens in the conservatorship process is someone files a petition to come and say this person doesn't have capacity. The way they prove that she doesn't have capacity, all it takes is one doctor to come and say she doesn't have capacity. The court will hire an attorney to investigate. The court will hire a court investigator to investigate. Once all of these parties provide reports to the court will appoint a conservator. The reason you want to avoid a conservatorship is because it, again, public, very expensive, and it's very time consuming. But sometimes conservatorships are not in the best interest. Sometimes, even if you have a conservatorship, if the person has dementia and they have Alzheimer's, they can still get up in the middle of the night and walk away. And it's then you have to go to court and change the residence. And then again, all the fees add up. You want to avoid this at all costs by having a durable power of attorney and an advanced healthcare directive. So I went through all of them. I went through estate planning, probate, and conservatorships. I think I just threw a lot of information at you at once, but Sammy, you want to go to question and answer.
And also on the registration, thank you for this. Yeah, it's a little unsettling, I've just got to admit. I mean, some of this stuff, it's like you don't really think about, you know, getting into a car accident, what happens and who has access to your, I mean, it's like, it's sort of weird because you're sort of planning for all these, you know, not great things, but if you don't plan, then,
Yeah,
you know.
It's kind of like you're not planning for them to happen, but you're kind of planning for your peace of mind, just to know, right. God forbid, in the worst case, like life insurance.
Yeah, right.
Hopefully
yeah,
will never
exactly.
be needed, but knowing that you have life insurance kind of gives you this peace of mind that worst case scenario, your family is protected.
Right. No, thank you. I mean, we had some questions too, specifically about like house, like buying a house and how to, like, ways to hold title. And so one question was like, what happens if my parents added me and my siblings to the deed? I think as joint owners or yeah. So just could you talk? And then generally there was a question about, you know, like an unmarried couple holding title but not in a trust. Like, can you talk a little bit about owning a house and how to avoid probate?
So first, let's talk about the situation where parents decide to add their kids on title as joint tenants so they can avoid probate. It's a huge misconception thinking, okay, I don't want my kids to go through probate. I'll just add them to title right now. Okay, they'll avoid probate, but what people are not considering is capital gains tax, and people are not considering, especially as a result of Prop 19, property taxes going up. So first item I'm going to touch base on is the capital gains tax. In California, there's something called capital gains tax. If you buy something, and that whether it's a real property or whether it's an investment, if it gains value, if it goes up in value, the state of California requires you to pay them tax on the money you earned. So they look at the base. You bought something for $500,000. It goes up to $600,000. You sell it, you make $100,000, but you have to pay capital gains tax on that $100,000. What happens if you inherit money through a trust is when your parent dies, let's say they bought a house for $100,000 and they die and it's worth $500,000. So there's $400,000 gain here. Who's going to pay this capital gains tax? Well, if your parent dies and you inherit it through a trust, it comes up to here, and then you're at the $400,000. But since you inherited it, you don't pay capital gains tax of it going up from 100 to 400. The government looks at it as just getting it at 400 because you just received it. You inherited this property at 400. So there's no capital gains tax. Should you hold on to it for 5 years and then sell it here and it's gone up to 100,000, you pay capital gains tax on what it's increased since you've received it. But if you inherit it from your parents, you don't pay capital gains tax from the amount that it increased when your parents bought it. Now, the reason I'm explaining that is because if your parent adds you to a title as a joint tenant, you lose this step up. So what happens is your parents add you as a joint tenant, your parents die, guess what? You're going to have to pay capital gains tax on the amount the property increased from when your parents bought it until it became yours. That's a huge, significant loss that could have been avoided by just putting the property in a trust. Another reason is now this past February 16th, there was some change in property tax laws. And before this past February 16th, every time there was a transfer between parents and kids, there was a form you can file with the assessor's office and the property taxes would stay the same. But the assessor's office are always waiting for a change in ownership. And they're just waiting to raise the property taxes. So every time you buy a property, your property taxes are calculated from when you bought it, not when the previous owner bought it. So what happens now as a result of Prop 19 changes, if a parent transfers a property to a child or adds a child to the property, property taxes may go up The only exception is if the child is living in the home and that's their personal residence. Besides that, property taxes are going to go up because Prop 58, it's Prop 19 and 58 has been changed. So it no longer is an automatic exclusion between parent and children. It's only now an exclusion if the child also has that house as a personal residence. So this is why you don't want to add kids as joint tenants to your property. You lose the capital gains tax, the benefit of the step up, so you don't pay capital gains tax. And unless the house is the child's personal residence, then the property taxes are going to go up, at least the one half that's considered to be the child's. Okay. The next.
Yeah, and that's great. It's great to also, you know, if you have an estate plan, to also have a good CPA and, you know, be able to plan for those tax implications.
Yes.
And so what about like an unmarried couple buying a house together?
So an unmarried couple, when people buy houses now, husband and wives who buy a house together, and Sammy, correct me if I'm wrong, but the default these days has been husband and wife is community property with right of survivorship. And the reason that's become more prominent is that what that means is if husband dies, it goes to wife, and if wife dies, it goes to husband. You might think, okay, well, we're just husband and wife, and it's automatically going to go to the other one. We don't need a trust. Well, you will need a trust, because what's going to happen after the second of you dies? Then the house is subject to probate. So the benefit of having it in the trust is to protect the second level of distribution. Mm-hmm. Now, what happens to a couple who's not married? Boyfriend, girlfriend, buy a house together. So in that situation, either they're going to hold it as joint tenants, or they're going to hold it as tenants in common. Joint tenants mean when one of them dies, it automatically goes to the other. The other tenants in common means when one of them dies, it's going to go to his side of the family, and when she dies, it goes to her side of the family, subject to probate. Joint tenants, if one of them dies and it goes to the other, then it's in that person's name alone, subject to probate.
Oh, so if you're joint tenants, unmarried, it goes directly to the other person, but through probate.
No, not through probate.
Oh, not through probate.
We'll go to them, but then when they die, it's subject to probate.
Got it. And so can that be redefined or restructured by a trust or a will? Ruth Ann.
Yeah, so in a situation where people are not married and they have an estate plan, you can't create a trust for people joint. It's very rare to do so. And it's not advised to do so. So basically, when you have a trust, each person is going to have their own trust. So maybe boyfriend and girlfriend want their share to go to the other one, or maybe they don't. They want it to go to their own family members. But then they would have, each of them will have their own trust.
Okay.
To keep their one half interest in trust.
And there was a question about individual versus couple trusts. Like, is that how would those be structured separately, differently?
It just depends. Whenever you either do an individual trust or a couple's trust or a joint trust. The joint trust has different provisions. It says if husband dies, it goes to wife. If wife dies, it goes to husband. And it has different safeguards as far as taxes go and estate taxes go. And then it goes to distribution to kids and other beneficiaries. A joint trust says, this is who I am. These are my assets. When I die, this is who's going to inherit my money. If these people are not alive, this is who it's going to go to. And it goes then back to just the regular administrative provisions.
Okay. And so we had a follow-up question. So the default is the law, but that can be changed by both writing out in a trust how they want their portion of the home or estate to go.
Yes.
Cool. Okay. So basically, if you're married, you would be doing a joint trust. If you're unmarried, you could do a joint trust, but you would say you would just do an individual.
You would do an individual. Trust. Yeah.
even if you both own property together.
And to answer the question regarding the default is the law, there's something called laws of intestacy. And the law of intestacy is who's going to inherit your money when you die. And in California, it's called intestate succession. So it goes through a formal. If you have a spouse, if it's community property, money that was earned during the course of your marriage, all of it goes to your spouse. If it's separate property, meaning money that you had before you got married or money that you inherited through your own parents, your spouse gets a third. If you have more than 2 kids, they share 2/3. If there's only one child, spouse gets 1/2, the child gets 1/2. Then, so if there's no spouse, then we go down to kids. If there are no kids, we go up to parents. If your parents are not alive, we go to your siblings. If your siblings are not alive, we go to your nieces and nephews, and so forth. It's down and up. That's the law of intestacy. But the law of intestacy is distributed according to probate. So then your family is subject to probate, and then that's how the probate court distributes it.
Right. So basically, it's like if you don't write it out, it's going to go through this weird waterfall of intestines. Okay. And we had a question: if a property's in a trust, when that person dies, do the property taxes in California increase when the property gets passed on to the new person?
No. So it depends who the new person is. If the person is the spouse, it does not. If the person is a child, it does, unless the child is going to make that home their personal residence. Now, you might think, how long do they have to live there for it to be considered their personal residence? This law is very new, but so far what's been circulating is that 1 year. If they make it their personal residence for 1 year, then they can preserve the taxes. Now, I'm not 100% certain because this was just passed and we don't really know, but that's what the interpretation is.
When that happens, you call Deb and you say, what do I do?
Yeah.
Okay, so capital gains, Prop 19. And so, there's real estate focus too. So I know, and I do, and other folks do own rental property out of state, out of California. So how does the trust interact with property in other states, and what happens if you have an estate plan set up and you move to another state? I guess those are two separate. But
so first question, what happens? You live in California, this is your residence, and you have property in Pennsylvania. So what's going to happen is you just can transfer the property in Pennsylvania into your trust in California. Some attorneys prepare the deeds themselves. I don't like to prepare deeds for other states because, every state has their own nuances, and I would never want to make a mistake on a deed. So I would either advise you, there are companies, USA Deeds is one of them. There are companies who prepare deeds all over the US. Or if you're my client, I help you find an attorney in that state to help you make that transfer document. So that's number one. What happens if you have an estate plan in California and you move? It's usually documents are universal. Their only negative is maybe, for example, I'm just using Arizona as an example, but like maybe you move to Arizona and Arizona requires this specific provision that your trust doesn't have. My recommendation is for my clients, if they move to another state, is to have an estate planning attorney in that state do a review of their trust, pay them for an hour of their time to see if there are any specific provisions that need to be in your trust that isn't. But have I ever seen a problem with this? No.
Okay, got it. So you can sort of you want to keep the estate plan in the state that you're in, or if it needs any specific changes, just check it out if you're moving. Got it. So speaking of, what's the kind of the general ballpark of a pretty basic estate plan, not getting too complicated in terms of cost?
Oh, the cost. So costs vary, but my cost is I charge $2,500 for an individual and $3,500 for a couple. And that includes the entire estate plan, all of the documents. And the way my procedure works is first, we do a call, and if we connect, then great. I'll send out a questionnaire. It just asks basic information. It helps the individuals to kind of get your thoughts together and decide, well, who's going to be making financial decisions, who's going to be making medical decisions. And then once that's set up, we do another meeting where we'll go through that together and we design a plan together. I'll ask a series of specific questions. I'll answer questions. And what I do after the meeting is actually send a summary of what we discussed in Word format to my clients. So that way, if I'm missing any information, I ask them to fill it in. If they have any questions, they can type it in there, and then they'll send it to me. And once we've committed to a final draft, that's when I'll prepare the drafts. And then we'll do another meeting where we'll go over the drafts together. If anybody wants to make any changes, they can. Today, I had a client say, I completely forgot there's this friend of mine who'd be a great guardian. So we're changing the guardian provision. So it happens, and we'll go over the drafts together. If there's any changes, I'll make the changes, and then we'll do a signing meeting. And as a result of COVID, because of Zoom, things have been so streamlined, and a lot of these meetings are on Zoom. The signing meeting just takes 15 minutes in person because we've already gone over everything. And I'm a notary, so I notarize the documents, and that way the client, and I don't charge for that. So the clients are at least able to save a couple $100 on not paying for a notary service.
It's a lot of documents and a lot of signatures.
Yeah, and they can charge you $15 per signature and travel fees.
No, thank you. That's helpful. I think, just kind of, I think it sounds like people sort of come to you when they have kids too. I mean, maybe the first home buyer. I mean, I think specifically, and this is in the context of this, like I help my clients buy houses, and I remember, basically you're in escrow, and then title emails you and says, how do you want to hold title? And there's like a trust or an LLC, and you're like, what? I don't know. Like we did a title workshop as well. And, I feel like people are just start Googling like, wait, am I supposed to have a trust? Like, so it sounds like people kind of come to you afterwards when they've realized like they're not as prepared. So, it sounds like you can also
I've had people call me saying, we're closing escrow in 7 weeks. Can we do this? We really want it to go straight to a trust. So I've made things a priority to get it done.
Well, and so I guess a question I had too was about making changes, like if you've done something one way, how easy is it to change things? You mentioned that.
Yeah, so you can make changes if you ever want to make a change to the Advanced Healthcare Directive, the Durable Power of Attorney, or the HIPAA authorization, we'll just do a new document. Mm-hmm. There's no way to actually make specific changes. We will just redo that document. Now, if you want to make a change to your trust, here we're looking at a 40, 50, 60-page document. What we do is it's called an amendment. So you can have 20 amendments, but it would say, First Amendment to the John Smith Living Trust, and say, I am hereby replacing Article 2 with the following Article 2. So you literally just type the paragraph you're taking out, and then you put the new language. Sometimes you don't even need to type the paragraph you're taking out. You're just saying, this is going to be the new Article 2. If you're changing the distribution provision, you've decided you don't want your nieces and nephews to inherit. So it's easy to change. Attorneys charge hourly for that work. So for me, if it's a 5-minute conversation where you tell me you're changing the beneficiaries, the time it takes me to do it and signing, probably an hour or an hour and a half of my time to do an amendment.
Got it. Cool. And then going back, we had a question about parents putting their sibling's name on title, thinking it would just make it easier. So what would you recommend in that situation for parents who do that, thinking like, how do you sort of fix things if there's no other protections in place? Like, how would you handle that?
So in that situation, the damage is kind of already done, because so now if you're going to be doing another deed, Now, if mom and dad want to have a trust and child is going to put the property in the trust, the damage is only in the situation of property taxes. So the portion that went to child and is being transferred back, that section, that 50%, the property taxes may go up, but you're able to preserve the capital gains tax because when your child inherits the property, then they don't pay, they get the step up in basis.
So you would put it in a trust, even though, because then the next generation benefits from that, or no?
It's not the next generation. It's the, so how do I say it? Okay, we're in a situation, I'm just going to keep it simple. Mom added daughter on title. So now it's mom and daughter as joint tenants. Now, what do we do now? Mom can create a trust. Mom can put her half in the trust, and daughter can sign over something, putting it in mom's trust. But what happens is it's called, when daughter is giving it to mom's trust, that's called a change in ownership again. So that one half of the property is subject to property tax increase.
Got it. Can they put half? Can the parents just put their half in a trust?
So whenever you have a joint tenancy, good question. Whenever you have a joint tenancy and one of the parties decides to put their one half in the trust, they sever the joint tenancy. So then if daughter dies, then her one half is subject to probate. So then she also needs to put it in a trust.
So you just start raining trust everywhere. So in terms of, is it correct to say a will is a little bit more like your plans and desires, and trust is more about like money and like how would you define the difference between a will and a trust?
The main difference between a will and a trust is that a will has to be probated. They kind of serve the same purpose. You say what your assets are and who's going to receive your assets. A trust does not go in front of a judge. A will has to be probated. So if you have a will, you don't avoid probate. The only difference is, instead of it being distributed according to the laws of intestacy, it's going to be distributed according to your will.
Mm-hmm. Okay, got it. So a trust is just sort of, it doesn't, so if you have a trust, but you also have a will, you do avoid probate? Yes. Or the will still has to go to probate?
No. So if you have a trust, so you might think, okay, well, if trust is giving me all the protection in the world, why do I need a will, right? But the will is kind of your backup. The will is just in case you've forgotten to put something in the name of your trust. The will, remember, is going to pour it into your trust for you. Mm-hmm. And the will is the document that allows you to name guardians for minor children.
Got it.
So that's the purpose a will serves in an entire estate plan. It's a backup to any assets that you've forgotten to put in your trust, and it allows you to name guardians for minor children.
All right, so the trust is like the mama.
Yes.
And then everything else is like stuff in there.
Well, everything else kind of serves, I think they're just as important because you want to avoid a conservatorship as much as you want to avoid a probate. Sure. But the will is kind of like a backup. But then again, the will is very important because that's the document that allows you to name guardians. And you don't want aunt on one side and grandma. I actually had a guardianship situation where mom died and dad was very distraught. So dad's mom, grandma, and mom's sister became co-guardians. It was great until they stopped getting along. So it would have been nice if mom had a will saying that she just wanted her sister to be guardian.
Right. No, that's, yeah. Grief is an interesting time to be making all these choices.
Yeah.
Back to the mom, I think the parent thing is a big question, especially in California, Prop 19. I mean, there's taxes. California has high taxes. So I think it's a big question. You probably get a lot. But would it be possible to remove mom from the deed and just put 100% of the house in the trust?
Yeah, mom could transfer her interest to you, and then you can put it in your trust.
But then but you are paying taxes. You're not avoiding the taxes.
No, unless you both live there.
Right, because then if mom's living there, then she's living in a house she doesn't own.
Right.
You're renting it to her.
Yeah, because the assessor's office looks at what the change in ownership is, and the assessor's office is waiting to raise your taxes. So now the exclusion that they've allowed is if it's your residence, then you don't pay taxes. So if mom is giving it to child, the child can also prove that it's their personal residence, property taxes will not be affected.
Got it. There was a question of, can creditors come after money in your trust if you get sued?
Yes.
There you go.
That's another misconception. A revocable trust is connected to your social security number. It doesn't have its own tax identification number. So when people are worried about getting sued, we look at it in two ways. If you have a lot of real properties, you may want to consider putting them in different LLCs. But putting it in a different LLC, you have to have formation documents. You have to pay to someone to file taxes for you every year, and you have to pay $800 to the franchise tax board every year. So it's like you have to balance it out and say, does it make sense for me to put everything in different LLCs? In addition, another recommendation is if someone is worried about getting sued, first, if you're a professional, you have liability insurance, and sometimes you just have to just accept that. Another protection would be having an umbrella insurance policy, just having something that's going to cover you in any situation, and it might be worth it. That might be worth more or be better for you financially than putting everything in different LLCs. You could have as many real properties as you want in a trust. So you have 5 properties, rental properties, you can easily put them all in your revocable trust. But as far as the liability goes, you have to make a decision if it's worth to put it in an LLC and have all those expenses associated with it, or is it better just to have a big umbrella insurance policy?
Well, and so if you are an investor who has properties in an LLC already, how do you make sure those are included in the trust?
Good question. What we'll do is just an assignment. It's going to be a 1 to 2 page document that says, I hereby own this LLC. I own 100% in this LLC, and I am hereby transferring my interest into this LLC. I'm assigning my interest in this LLC to my revocable trust.
When I die?
No. It doesn't get recorded anywhere. It's just part of your body.
But it stays in the LLC.
Yes.
The property, but your interest in the LLC, your personal ownership in the LLC is now transferred to the trust.
Yes.
Got it. You're so good. So are you getting that if you are doing real estate, you need to talk to an estate planning attorney? And then I think there's the last couple of questions. There was questions about what's a revocable versus an irrevocable trust. And for a
So are we talking Laura's question, or did I miss another question?
That was a question from before, and then Laura's question, for a revocable trust, who's the trustee?
So
who is that?
That's an easy answer. Usually 99.9% of the time, the creator of the trust is the trustee. You're going to own it and you're going to control it. You're going to name backup trustees in the event you don't have capacity or you die. Now, sometimes some parents are just old and they just don't want to deal with it. So what they do is on the onset, they just create the trust, and off the bat, they make a child of the trustee. But that's not as common. So 99% of the time, whoever's creating the trust is the trustee.
And what's irrevocable?
Okay, irrevocable. An irrevocable trust is a trust that you cannot make changes to because it's irrevocable. But the benefits of having an irrevocable trust and why people create irrevocable trusts is because if you have a lot of money And in the eyes of the IRS, you want to protect that money from your estate so your kids don't pay estate taxes. If you put it in an irrevocable trust, it's going to get its own tax identification number. And in the eyes of the IRS, it doesn't belong to you. So it's not considered to be part of your assets to then be subject to estate taxes. Now, I didn't touch base on estate taxes much because right now the estate tax limit is so high that very few people are subject to the estate tax to pay estate taxes. California, you don't pay inheritance tax. But what estate tax is, if someone dies right now, an individual can die with almost $12 million and the estate is not subject to estate taxes. So 2026, that number is going to change, but we don't know if it's going to stay or if it's going to go back down to like 6 million. But even then, that's still a pretty high number. And then if you have husband and wife, they each get their exception. So then together, a husband and wife can have almost $22 million and not pay estate taxes.
Don't rule it out, folks. Invest in real estate early. You can get there too.
That's right. Talk to Sammy.
Yeah, if there's any other questions, throw them in the chat. But I think that's all the ones that I saw. And is there anything else that you think people should know?
If anybody has any questions ever, you can feel free to go ahead and shoot me an email or give me a call. I'm happy to answer questions. I'm sure Sammy's going to send my email, but my email is deb@debyounglaw.com. And just say you were a guest at this presentation, and I'm more than happy to provide guidance.
Awesome. Her info's in the chat. We'll put it in the description of the video here. And thank you so much. This was like amazing, such personalized questions, and you're just very knowledgeable. And I mean, I just encourage folks to do some research and, you know, make a plan. I feel like that's the piece that is missing, I think, when we start thinking about like real estate and building generational wealth. That's like really what I'm passionate about, is helping people think through that. And it's like, but if, you know, so then you've got to also put in the building blocks for all of it together, getting your money right, figuring out what you're doing. So thank you so much for sharing all this information. And yeah, appreciate it. Appreciate everybody.
Thank you for facilitating, and thank you for inviting me. And thank you everyone for joining.